Kyle. I'm a district court judge in Ramsey County and the chair of the Supreme Court's Advisory Committee on the Rules of Criminal Procedure. Our committee is comprised of judges and prosecutors, a defense counsel, and a few court administrators from around the state. I think there are about 18 total committee members. On June 18 of last year, June 18, 2021, the Minnesota Supreme Court directed this committee to review Rule 4.02 of the General Rules of Practice for the District Courts to, and I quote, consider whether the requirements set forth in that rule for audio and video coverage of criminal proceedings should be modified or expanded. Close quote. Since the issuance of that order, this committee has met regularly to discuss possible modification and expansion of Rule 4.02. Due to the pandemic, those meetings have been held via Zoom. They've been open to the public, and many members of the media and perhaps a few others have observed those meetings. Last month, this committee decided to invite any person or organization to provide written comments in support or in opposition of any modification or expansion of Rule 4.02. And we set the public hearing for today, starting at 1. We'll give it a couple hours. The committee did receive written comments from 9 individuals and organizations. And of the 9 submitters, 5 have requested permission to speak today. And those 5 individuals, I know they're all here. We have, and this we'll call them in this order, but we have Hal Davis from the Minnesota Coalition on Government Information. Good afternoon, Mr. Davis. And we have Jane Critley from the Silhog Center for the Study of Media Ethics and Law at the University of Minnesota. Good afternoon.
Good afternoon, Judge Kahn.
Yeah, and we have Joe Spear from the Mankato Free Press. He's also a board member at the Minnesota chapter of the Society of Professional Journalists. Good afternoon, Mr. Spear.
Good afternoon.
And Judge Lois Conroy is here. She is a Hennepin County District Judge and the current president of the Minnesota District Judges Association. Good afternoon, Judge Conroy.
Good afternoon. Pleasure to be here.
And we also have Lita Walker, a media attorney for the law firm Ballard Spahr. Good afternoon, Ms. Walker.
Good afternoon, and thank you for having me.
Yeah, thanks for all being here. So just the general ground rules, we're going to let each speaker give them 15 minutes or so, and we'll present in the order that I just named the speakers. There will be a time for committee members for committee member questions after each speaker concludes their remarks. I will then call the next speaker. As time permits, I may allow additional questions and answers after our 5 speakers are done. And if they're able to stick around for this whole session, that's great, but we'll take who we can get. And at that time, I'll ask members of either the committee or public if they have any questions they can inquire of our speakers. Or committee members. I'll just ask that everyone who asks those questions at the end use your raise the hand button on Zoom, so we just have so we can then call you and make sure that we get everyone. And of course, our committee members, I would ask, as I did earlier, if you could use your videos so that you're there, and of course our speakers. I'd ask everyone else who's not a committee member or not a speaker to keep their video off. It just makes it a little easier for everyone to focus on the. Finally, I should note that the state court administrator has approved media recording of this hearing, this public hearing. So with
very
that,
good.
Excuse me?
I said that was very good.
So I didn't quite catch that, Mr. Davis. We had a little bad connection.
I merely said that it was very good that you're allowing media recording of this session.
Well, I know there were a couple of requests, and so we took it up with the court administration, and it was approved, and I approved it. So, unless someone has a question, I think we'll get to the main purpose is to listen to some of our members, some of the public, the media, and Mr. Davis, I think you're first on the list, so I'll give the floor to you.
All right, thank you very much. I'm hoping people can hear me. I have an occasional notification that my internet connection is unstable, so I hope I stick around for all of this. Minnesota Coalition on Government Information is a nonprofit volunteer group of lawyers, journalists, librarians, film producers, data freaks, people who believe that the more people learn about how their government works, the better off they are. We believe the people of Minnesota should be able to see their criminal and civil justice system play out in court proceedings. More formally, it is our right as citizens to view the judicial process at work. You'll be hearing from Lita Walker, who represented a media coalition that covered the trials of Officers Potter and Chauvin, so I won't dwell on them. But absent COVID, we have the current rules. And some defense lawyers contend that the current rules give the public a distorted view of criminal defendants, since video is allowed only after a finding of guilt. Brief camera coverage of sentencing hearings doesn't shed light on what has occurred in the course of a criminal case. And Koji agrees. The best way to shed light would be to allow cameras at every stage of criminal proceedings, since many such cases end in acquittals. At one point, Court TV's hard drive of the live stream of jury selection and trial of Derek Chauvin is Court Exhibit 30. It was available to the public for several weeks. Anyone who had a suitable hard drive and paid the copying fee could get the public record of the entire trial. I would consider that excellent. One member of this committee has suggested that the Minnesota Judicial Branch provide video coverage of all trials. This would alleviate criticism that may be legitimate, that media only show up on the days of opening, closing, verdict, sentencing, and perhaps some testimony. A video record of all trials would eliminate that probability, that possibility, and that probability, and leave the entire record available to the public. And a video record of all trials has been the case in at least one state, Ohio, since 2012. The effect on Ohio jurisprudence, Ohio Chief Justice Maureen O'Connor wrote that as a prosecutor and trial judge, I spent nearly 3 decades in courtrooms with cameras, and over the past 10 years have heard hundreds of cases at the Ohio Supreme Court that were broadcast live on TV. She wrote, I have seen no evidence that the presence of Koji believes that open, transparent courtrooms, including broadcasting proceedings with reasonable restrictions, support public understanding of the courts and foster trust and confidence in the judicial system. That's essentially our statement. I'm available for any questions anyone has.
Any committee members have a question for Mr. Davis? I want to thank Mr. Davis for his presentation and making a written submission also, but do any committee members want to ask any questions? Okay.
Actually, I'll ask one if I may.
Go ahead, and then I see Mr. Judge Reyes has his hand up too, but go ahead, Mr. Morning.
So Mr. Davis, you and a lot of the other comments that are pushing for an expansion of the current protocol point to the Chauvin case and the Potter case. What confidence do you or should we have that those two exemplary matters will be how things are done in cases that are otherwise dissimilar?
Well, I have confidence in the Minnesota judiciary. I have confidence in the ability of district judges run their courtrooms in a manner that defends the rights of all parties. And I would say the experience of these two trials would be Exhibit A of how a trial can be conducted with universal attention and be fair to the participants.
So what about the question that how these two cases played out would be Exhibit A to how cases like this can be covered, but does not particularly inform how cases with less total media attention and national attention and issues of indeed global concern would have. And while I appreciate the vote of confidence in the judiciary, it's also about the media and whether the media will respond responsibly in other situations, in other cases.
Well, you had Court TV, which has a lot of experience covering trials from beginning to end, cooperating totally with the judicial system here. I don't think there were any objections that I'm aware of. We did have just televising the trial. This is the televising of the Potter trial will not and does not violate the defendant's right to a fair trial. She wrote the Chauvin trial should allay any trepidation about cameras in the courtroom. The experience seems to bear out that cameras do not distort justice in the state of Minnesota.
Judge Reyes, I know you had your hand up.
Yes, thank you very much. Thanks for your comments, Mr. Davis. We really appreciate them and your written submission. I have two questions for you. The first relates to your written submission, and you highlight the experience in Ohio in particular. Are you aware of any other states that have a similar procedure or system as Ohio? And what are the results of those states?
I am most familiar with Ohio because I spent 10 years of my journalism career in Ohio. We live next door to Wisconsin, and I have a feeling there are people who will be addressing this panel who are more familiar with Wisconsin, for example, where I have a feeling cameras in the courts have been the case for get national as well as just local attention. And so far as I know, Wisconsin jurisprudence is still functioning.
Okay. And then the second question I have, it relates to, and this goes to your comment about confidence in the judiciary, and we certainly appreciate that. But at the same time, we give trial judges, district court judges, great discretion in terms of how they handle their courtroom. And that includes what happens, who testifies, who's there, protection of, for example, minors when they're testifying. Are you advocating for unlimited use of cameras in the courtroom, or do you think that the district court judges should have some discretion to limit them and look at various factors to make sure that witnesses are protected, protected decorum in the courtroom, etc.?
Okay, I'm afraid I lost part of your question, Judge Reyes, but the short answer is no. There are clearly ways to conduct
I think we may have lost Mr. Davis. He was having a little bit of a technical.
Okay. I'm sorry I lost part of your question, Judge Reyes, but the short answer would be the judges still control the courtroom, and I don't believe I'm not asking for a blanket opening of every witness to camera coverage. Clearly, there are distinctions that are made based on each case and each witness's situation. But I would recommend that the default be that camera coverage be allowed at every stage of a proceeding.
Okay, thank you very much.
Any other questions? Any other committee members have a question for Mr. Davis? Okay. Well, Mr. Davis, thank you. I appreciate your comments, and you're welcome to stick around and listen in for the rest of the session.
I think I will. Thank you very much.
Okay, thank you. So our next speaker is Ms. Critley from the Stillhouse Center for the Study of Media and Ethics and Law. Go ahead.
Thank you, Judge Kyle, and good afternoon to you as the chair and all the members of the advisory committee. I appreciate you allowing me to testify today. As you know, I'm the Silla Professor of Media Ethics and Law here at the Hubbard School of Journalism and Mass Communication, which is at the University of Minnesota. I also direct the Silla Center for the Study of Media Ethics and Law, and I'm an affiliated faculty member at the University of Minnesota Law School. I do want to clarify, and many of you are government employees, so I know you'll appreciate this, that the written comments I have submitted in my oral exchanges with you today are presented on behalf of the Center and do not necessarily represent the position of the University of Minnesota or the law school on this topic. This is a topic that I've been working on for most of my professional career. When I was at the Reporters Committee for Freedom of the Press, we were advocates for cameras in the courts all over the country. I was involved in the federal pilot project way back in the 1990s, and it was not all that many years ago that I testified here in Minnesota in support of cameras in the courts. So I have a long chain of experience with this issue, and I'd like to begin by observing that this is truly a momentous occasion. As you are considering the question of whether the Minnesota rules governing cameras in the court should be permanently expanded, I'm confident that you join me in reflecting on and acknowledging the unmitigated success of cameras in the courts in both the Chauvin and Potter trials. As you all know, Minnesota has been singularly cautious about permitting cameras in criminal trials and pretrial proceedings. There are many reasons that were articulated for this, and you're familiar with all of them. There were concerns about preserving the constitutional right of defendants to a fair trial. There were concerns that lawyers might act out or play to the cameras. There were concerns about the privacy of jurors and witnesses and victims and their families. And there were concerns that the presence of cameras themselves would disrupt courtroom decorum. Happily, none of these concerns have come to pass, thanks to the professionalism of the judges, the attorneys, and the journalists involved, which ensured that these trials were conducted with dignity, preserving the rights of the defendants and the right of access guaranteed to the public and to the press. In short, this should be a time of celebration and affirmation. We should be proud of what we as Minnesotans have accomplished here. You have before you the written comments that I submitted earlier this month. I want to thank two of my Silla Center research assistants who are law students here at the University of Minnesota Law School, Samantha Brunn and Claire Colby, for their help. I won't rehash those comments this afternoon, but I'd be happy to answer any questions you might have. I would like to take a few moments to emphasize some points. First, as you know, the First Amendment guarantees a right of both the press and the public to attend criminal proceedings. It is true that the Supreme Court of the United States has never explicitly extended this right to the electronic media, but as we have all learned, the COVID-19 pandemic created a greater challenge to public and media access to the courts than ever before. Fortunately, with the wide availability of online and streaming platforms such as the one we're using today, it has been possible for courts around the country, and even the U.S. Supreme Court, to open up their proceedings to the public in a truly unprecedented way. It's a paradox, isn't it, that during the pandemic, when life for so many has been disrupted and circumscribed, use of these new media platforms have proved again and again that meaningful audio and video access can be provided to the public and the press remotely without disrupting proceedings or undermining other legitimate public interests. In my opinion, it would be extremely unwise for the Minnesota courts to go back to the pre-COVID status quo. I would even suggest that it would be unacceptable to the public. As you know, there was a strong reaction both here in Minnesota and elsewhere when high-profile criminal trials such as the Ghislaine Maxwell case in New York and the just concluded federal civil rights trial in St. Paul were conducted without cameras. Even though it was explained over and over that federal court rules prohibit camera coverage and that the presiding judge had no discretion to admit them, social media chatter imagined all sorts of conspiracy theories about why the public was being excluded. To me, this illustrates a point that I raised in my written comments and that others will also discuss. For better or worse, and of course I think it's for the better, Minnesotans now have an expectation that audio and visual coverage of criminal proceedings will be the norm in this state. They welcome the opportunity for meaningful access by ordinary individuals who would not have the time or the resources to attend a trial in person even if COVID capacity restrictions were no longer a factor. They are truly thrilled to have a window into the often secretive and arcane world of criminal trials. As lawyers and judges, you take this kind of access for granted. But without cameras, realistically, it's inaccessible to the majority of the population. I remind you that the courts operate on behalf of and in the name of the public. As citizens, they have a right and a duty to observe how judges and lawyers are doing their jobs and to provide the public oversight that every institution of government needs, particularly at a time when confidence in our institutions has been eroded, in large part because of misinformation and disinformation spread by those who seek to undermine them. It is all the more essential that we provide the public with meaningful access. As former Chief Justice in Minnesota, Warren Burger, observed, people in an open society do not demand infallibility from their institutions, but it is difficult for them to accept what they are prohibited from observing. I believe that the public interest has benefited from the window camera access has provided into the practical application of the rule of law and judicial independence, both of which are cornerstones to a functioning representative democracies. I ask that you keep that window open by expanding camera access to criminal courtrooms. That concludes my remarks, but I'm happy to take questions and comments.
Thank you for those comments. We appreciate it. Any committee members have questions or of our second speaker? You can just raise your hand or just speak up. I won't require the little reaction on the Zoom screen if you have any. I've got one, but I'll let a committee member if they have any.
I have one.
Go ahead.
Thank you. Are there any types of cases that you think should be excluded from cameras in the courtroom?
Well, I believe that this norm should be access, but as we know from U.S. Supreme Court precedent, there are certain types of proceedings, or I would say certain aspects of certain proceedings, where it would be acceptable to exclude the public, the press, and under those circumstances, clearly cameras would not be present otherwise. I'm thinking back to the Globe newspaper case where Massachusetts had a law that said that whenever the victim of sexual assault, who was also a minor, was going to testify, that segment of the proceeding would be closed to the press and the public, and of course, presumably cameras as well. The key, though, is that any closure or restriction should be narrowly tailored, as limited as possible, and serving a superior, compelling state public interest. I'm not here today to define in precise terms what those parameters would be, but one thing that I've often said in the context of cameras in the courts, that at least when you're kind of moving into it as a beginning proposition, it is appropriate to look at state precedent on where proceedings might otherwise be closed to the press and the public, and to start there. And I'm not here today to argue that those proceedings, if they're customarily closed to the public, should suddenly be open to cameras. I'm simply asking that this access that is permitted now to the pencil and paper press would also be extended to the electronic media.
Any other committee members have a question for Critley?
I do.
Yeah, go ahead, Nick.
Thank you, Professor Critley. Thank you for being here today. I appreciate it, and I appreciate your written and oral thoughts here today. One question that your last answer just brought to my mind is that you talked about essentially that, in your view, cameras should be allowed, and then sort of provided a test that to me almost sounded like a strict scrutiny type of test where the exclusion of cameras would need to be essentially narrowly tailored and only if there was a compelling interest or something to that effect. So are you suggesting then that essentially the rule in your mind should be that cameras must be allowed in public criminal proceedings unless there is really a very strong reason not to do so and only to the very minimal amount essentially needed? And I guess that to me that just sounds like a constitutional test more of a prudential what should the rules be. So that's why I asked the question.
Well, I'm happy to try to respond to that. I mean, I'm always going to fall back on constitutional standards because I think they serve us very well. I mean, I acknowledge that the Supreme Court of the United States has never said there's a constitutional right to cameras. But if you look, for example, at the Florida experience, and I'm sure you all have at various points during your meetings and deliberations, they're unusual in this country because they start with a presumption of access, which of course is where we would start for any with so-called expanded access, electronic access would begin. And I favor that, but I realize that that may be a step too far at this stage in this state. I would advocate for it, but I would understand if there was some reluctance to adopt it. But truly, I think that the presumption should be that cameras should be present in any situation where the news media and the public would be allowed to be present. Now, as Mr. Davis discussed and others have acknowledged, the judges in this state, just like in any other state, have a great deal of discretion to try to control exactly what's going to happen in their courtroom. And I'm in no way suggesting that they're ceding that authority if cameras are going to be permitted. They will still have that authority and they will still utilize it. It will be subject to challenge by the news media if they think that a judge is overstepping. I can't guarantee that won't happen. In fact, I can guarantee you it will happen. But that is a separate question from whether cameras ought to be present. And if I could, I'm going to take kind of the liberty of just making one other observation, which is that I think that it's really important to draw a distinction between the right of access and the right to disseminate information and what impact that dissemination might have. I know that in previous iterations of this committee, there were a lot of concerns about how the public would react to what they would see that the news media were providing. And with all due respect, I think that that is really not within the court's control. The public is going to react the way the public reacts. And as Mr. Davis suggested, more information, more accurate information, I think is always better in terms of informing them. But you can't, I know judges love to control their courtrooms, and it's absolutely appropriate that they do so, but it's very difficult to control the public reaction. The best way to ensure that that's an informed reaction is to give the public the access that they have a right to.
Anyone else?
Yeah, I have a quick question,
Yeah.
Judge Cap.
Go ahead, Mr. Erickson.
Yeah, would you be satisfied with some sort of streaming of trials through the judicial branch website versus private media, actually being in the courtroom, so people would have access to watching the trial, but it wouldn't necessarily be covered by specific media outlets?
Well, I guess I would say that electronic media, I believe should have equal rights of access to those of the print media. So I would be less happy with that option. On the other hand, and I think this came up during Mr. Davis's testimony, the reality is that many, many trials will not attract media attention for a whole variety of reasons, some of it resource driven and some just based on what they perceive as the newsworthiness of the story. So although I'm not here to say that the media I'm not here to say that the media exclusively played the role of providing information to the public. We'd like our government institutions to do that as well. So I think that providing a streamed version, gavel to gavel coverage would be a valuable resource. What I guess the thing that would concern me, and you didn't say this, but I just would be concerned about it, would be if there were any restrictions on the further dissemination of that feed by the news media. That I would definitely oppose.
Anyone else have questions for Ms. Critley? No, I had one question. I know we've got another speaker coming, so we're getting close to our end. But you mentioned that there should be a presumption of cameras. That's your preference, and of course, district court judges are very guarded about their wanting to have discretion in their courtrooms. We've mentioned this a few times. In your paper that you submitted, you gave an example of the use of that discretion when Judge Cahill prohibited the video of the Floyd family in the Chauvin trial and juvenile witnesses, unless they consented, the jurors' faces. For our committee, we've got to come up with some rules and some language if we're going to propose to the Supreme Court, because we don't get the final say. It's ultimately the Supreme Court. But they're going to want to see some language to keep the judge's discretion. I'm not saying, I'm not hearing you say, or I don't think any of the speakers saying that the judges shouldn't have some discretion, but in terms of determining what criteria, do you think we should be putting in some specific examples, such as, juveniles off limits unless they consent, never show the face of a juror or maybe court staff, those kinds of examples?
Well, I think and again, I'm not equating it exactly, but as Justice Brennan said in the Globe newspaper case, where there was this statutory rule in Massachusetts that said, the press and public will not be present if the juvenile victim of a sexual assault is testifying. He said that kind of categorical exclusion is really problematic because, as all lawyers know and judges certainly know, case by case is the reality in much of law. In order to do justice, we have to look at the totality of the circumstances and the facts of the case. So I'm not comfortable with a laundry list that says we never allow, for example, video of the jury. Because I have a particular aversion to anonymous juries, and so this would be one example that I would give. But in many jurisdictions, that is such a restriction. So, and I'm sure most of the other people involved would be happy to work with the committee to try to come up with possible language. But just as a general proposition, I think categorical exclusions are not a good idea. I realize it's more work for the judge, but I think you get a more just result if you look at each case based on its facts.
Thank you. Okay, any last questions for our second speaker? I don't see any. Well, thank you, Ms. Critley. We appreciate your time, and feel free to stay and watch and participate perhaps at the end if we have some more questions.
Thank you, Judge Kahn.
Okay, our next speaker is Joe Spear from the Mankato Free Press. Mr. Spear, go ahead. Oh, you got on mute.
Thank you, Judge. I appreciate the opportunity to speak to the committee, and thank you to the committee for all the difficult work you're doing on this really important subject. I appreciate it, and journalists across Minnesota, I'm sure, appreciate it too. As I said, my name is Joe Spear. I'm the managing editor of the Mankato Free Press, where I've worked for 31 years, the last 16 as managing editor. I am also the media coordinator for the 5th Judicial District and 2 counties in the 1st and 3rd districts for the Cameras in the Court program when it started about 7 years ago. I'm the past president and current member of the Minnesota chapter of the Society of Professional Journalists, who I represent here today. So thank you again. As a media coordinator for this Cameras in the Court system, I've become very familiar with how the current system works. In the last 7 years or so that I have seen all the media requests from cameras in different districts, and I have heard no complaints from victims, witnesses, lawyers, judges, or others involved in a trial where cameras were allowed. I may be the only person or one of the few people you hear from that is boots on the ground with this issue, and I certainly welcome questions. But I submit that evidence of very few or little complaints from anybody, and evidence provided well by my colleagues, and the recent high-profile televised cases of George Floyd and Dante Wright, to strongly advocate that the cameras in the court be allowed in all criminal proceedings as outlined by various proposals and as reasonably determined with rules and proper discretion by the judge. I don't think anybody is calling for an all-out exposure of everything that happens in the court, although some of us would find that just fine. In all my years of journalism, I have met face-to-face with many people who are angry at the courts or who do not understand the courts. These folks were both victims, the accused, and the general public, who often think, for example, sentences are too easy on criminals. I realize there are competing interests here with press freedom and victim privacy, but the committee should also consider damage done to the institution of the judiciary by the current lack of transparency. Of course, complete victim privacy can never happen in public courts, or at least almost never happen. My colleagues and others will point out cameras in the courts have been the norm in our neighboring states for years. There appears to be little or no evidence of disruption of the courts or damage to victims in those states. As a member of the media, I appreciate recent outreach efforts of the courts to hold hearings in outstate locations and to allow for full broadcast of appeals court and Minnesota Supreme Court arguments from time to time. But the criminal courts have a broader impact on the public. It is the place where rights and freedom are decided. Freedom from incarceration in a democracy should be taken seriously. The governed have a huge stake in the power of prosecutors and judges and the freedom of the people. The masses have a right to easily see how their courts work. In the end, the truth is the truth. A camera doesn't change that. It only sheds more light on it. I'm more than happy to take questions. Thank you.
Thank you, Mr. Spear. Any committee members have a question for our third speaker? Go ahead, Judge Reyes.
Yes, thank you very much for your comments, Mr. Spear. And I note in your, well, let me ask you a question based on the statement you made. You talked about in your letter the lack of faith in the judiciary and court proceedings, and that transparency might help increase trust in our judicial system. And you highlighted the fact that, for example, people are concerned about sentences, particularly ones that appear to be too lenient. I'm curious as to how having cameras in the courtroom would alleviate that. Would that, how that would change that perception?
Well, I think the more people see about how justice is delivered, the more they can understand the end result. I think a couple of the other speakers pointed it out. We're all for more information, and we really believe when people have more knowledge, more information, they make better decisions. They understand things more. And a point I would really like to make is, excuse me, if we don't try to give them more correct information, more facts, social media disinformation will fill the void. People will believe what they see on social media, and then you've got a real big problem. You're probably already having a big problem because, I mean, the media has to deal in facts, the mainstream media, and social media will fill the void. But your question is a good one. I do believe electronic media can deliver information about how courts work in a way that's easier to digest than we might be able to give them in a long newspaper story. So I believe it really would help further educate people. I think I answered your question.
Thank you very much. I appreciate it.
Okay, absolutely.
Judge Johnson.
Yeah, hi. This is Paul Thiessen. Do you have any information on how people of different generations actually process information? You know, written versus video or audio, and are there changes going on that we should be aware of with regard to that?
Yeah, it's a great question, Paul. Yeah, we know millennials use phones and electronic media. Almost none of them will pick up a newspaper. 60 or 70% of our readers are probably over 65. So you really do have to reach out to the young people, and the way to get to them is the electronic, is their phone, is their tablet. Are these alternative methods of showing a video clip of the case? Anything like that is going to help millennials and the generations below, which is becoming the biggest demographic in our country. So it's extremely important we reach out to them. Thanks for that question.
Townsend, I knew you had a question, I think.
Yes, I was just curious about any perspectives, concerns, thoughts as it relates to broader access and any kind of issues with, say, witness or participant intimidation. And if there's any comments on that. In the Chauvin trial, I believe there was a witness that received some intimidation, and I think that there was issues with the judicial officer in the Potter trial. And I'm just kind of curious what the media's perspective is on that, and if broader access contributes or can help not contribute to that concern?
You know, I think Jane addressed this pretty well earlier, but I really believe, and we in Mankato in the rural area, we have really not had any of that issue. You know, with witness intimidation or attacks, it's certainly possible. And I would go back to, again, people not having enough information where they're motivated to get violent or in other ways, you know, because they got it on social media and everybody believes it on social media. So the more we can do to get the correct information out there to as many people as possible, I think the better. Of course, we'll never be able to completely control, I think, as someone said earlier, how the public reacts, Jane said earlier, and what they do. That's kind of part of the messy part of democracy here. We have to take risks with some of that, and of course we look to our law enforcement and the security folks to help us with that. And journalists are always willing to cooperate when we are told clearly, you know, what our rules are with security and safety of people. And so we're not fighting that. But to answer your question, I think it's a little of more information and a little of, we just have to take some risks sometimes.
Thank you. Any other members have a question for Mr. Spear? Mike. Good afternoon, Mr. Spear. And again, as the other members have said, thanks for being here. Great comments. I've got 3 comments, and I think they're related to how you described yourself as kind of boots on the ground. We've gotten quite a bit of information, comments about you know, the impact this has had in some of the trial cases where they've had the cameras in the courtroom. And I'm just curious, kind of anecdotally, in number 1, how many cases that you've seen the cameras in the courtroom? Number 2, what kind of restrictions you've seen judges put on them? And then, if any, what effect you think that that's had, as you know, being kind of boots on the ground and being right there on the front line? I think I'd be interested to hear that. Thanks.
Yeah, great, thank you. So I think I've probably been personally involved with our newspaper in maybe 10 or 12. Of course, in the last 2 years, we haven't done many because of the pandemic, but initially we were really involved in them. And I've seen other requests come through from other papers around the district. I think what we've found is the judges are more than willing to use their discretion from time to time. I believe we were completely, the judge decided no cameras whatsoever in the case of, you may remember it, this young man over in Waseca, John Ledoux, who had threatened to blow up his school and kill his parents. And even though he was tried as an adult, became 17, there were no cameras allowed in that. And, you know, that's the judge's discretion. I think we have, from time to time, I'm trying to think of other denials. There weren't a lot, to tell you the truth, that were super noteworthy. I think there were just a regular, one of them was it was a case where a baby was injured badly by a strange parent, and the judge decided that was a domestic case, so there was no cameras in that. And so he had discretion there. I guess it wasn't, you know, technically a domestic case, but most people were concerned about the sentencing of this person who hurt the baby. And I'm trying to think of other cases that might be noteworthy. Of course, one of the challenges news organizations have is reaching the victims, because you have to get their written permission, right? And so it's sometimes difficult. They're not in the phone book, and everybody's got cell phones now, so you sometimes have to have difficulty finding them to get their permission. In 1 or 2 cases, the prosecuting attorneys assisted us, which we thought was great. And when we talked to most of these victims, I find by and large are very willing to be photographed, and you know, when they know the rules, and very willing to tell their story. And that might be the other side of this that we're not hearing much of. Victims, you know, now want to speak out. We shouldn't hide that they were victims, because there's some risk of embarrassment or whatever. You're seeing more and more stories in the Star Tribune, for example, a year or 2 ago, where rape victims came forward and were photographed and told their stories willingly. So this may be an issue that will empower victims in some cases.
Thank you. Any other questions for our speaker? Yeah, go ahead.
Yeah, I just want to follow up on that point because I think the counter argument to that might be it's fine if victims want to voluntarily speak out, but if we have a presumption that cameras are going to be allowed in the courtroom unless there's an exception, what about the victims who don't want to be exposed and be on camera and for any variety of reasons? Because I think that might be a concern that a lot of victims might have.
Well, if that happens now, of course, yeah, right. They have to sign off on it. But if they were presumptively, filmed, we listen to people and we listen to victims, and if they tell us, we make a decision on our own ethical decisions. Should we honor their request, or is there a compelling reason to honor their request if we were allowed to do it without bothering with the rules? And I think so. There's that. There's the integrity of the journalism organization that would presumably consider it on their own, but you couldn't count on that because all news organizations are different, and they'll see it differently, and there'll be a need for visuals from broadcast more than print, perhaps. And that's one of those rules you may have to really struggle with in your committee. I can see both sides of it.
Okay, any last question for our speaker before we go to our next presenter? Anyone in the committee? Okay. Thank you, Mr. Spear. Appreciate it. You're free to stick around and listen up if you'd like.
Okay, thank you, Judge.
Yeah, thank you. Judge Conroy, the floor is yours.
Thank you so very much. May it please Chair Kyle, members of the committee, and Justice Thiessen, my name is Lois Conroy. I'm the president of the Minnesota District Judges Association. I want to thank the committee specifically for accepting our written submission, for hearing my testimony here this afternoon, and just your overall service on the Rules Committee. Each member of this committee has a lot of work to do, and for you to be designating so many hours on your Friday afternoon to hear these important issues, just want to express my overall gratitude for your service. I want to present a position of the Minnesota District Judges Association, which is that we object to any expansion of Rule 4.02 or a change of the rule that limits judges' discretion. While our board took a position regarding this matter last week, this has been a long-held position of the Minnesota District Judges Association going back to 2014, when we have carefully weighed the advantages and disadvantages of changes to the rule. Those advantages and disadvantages were once again debated amongst us judges, and the issues we keep coming back to is that it is critical in order to administer justice in our state that judges weigh factors that are specific to the case in front of them. I want to give you some examples. What is the nature of the case or the matter in dispute? What is the posture of the case? Meaning a camera in the courtroom may vary whether it's arraignment, pre-trial, trial, post-trial, or sentencing. What is the victim's position, or what is the hardship to a victim? We've already heard some of that testimony here today. I have reservation about requiring cameras in the courtroom and a chilling effect that may have on future victims testifying. That if a victim sees that another victim is testifying in front of a camera, whether it's on local television or on national news, what effect will that have on future victims in reporting crimes of violence, reporting rape, reporting a whole host of victim-type crimes? Not every victim has the same ability to withstand the stress of the scrutiny that would come with a video camera. The court needs to carefully weigh, is there a victim, the type of victim, the number of victims? There are cases in which we have no victim at all, in which it's the victim's family that we're weighing the well-being of cameras in the courtroom. But we also have to weigh the defendant's right to a fair trial and the public's right to observe. Judges routinely allow cameras in our courtrooms. This leads me to my issue about whether we are here today searching for a problem or a solution in search of a problem. We have many examples, as we just heard here in testimony this afternoon, that there are times in which judges allow cameras and there are times when judges do not. But it needs to be on a case-by-case basis in which the weighing of those factors that no rule could ever prescribe. If we just take the factors that we've talked about here this afternoon, there is no way to fashion a rule that encompasses all factors to come at a fair and just result. I also want to come to an issue that I feel like has been conflated in testimony here this afternoon, which is that if a victim testifies, the courtroom can be closed. Closures of the courtroom are carefully regulated activities by judges already, for which there is well-established law to determine when a closure is appropriate and when it is not. We allow our courtrooms to be open unless there is a definable reason to be not. Just because there's a camera not in the courtroom doesn't mean that the courtroom is closed. Our courtrooms are open to the public. They are open to journalists. And I will also point to the numerous examples in which judges have allowed cameras in the courtroom, in which minutes, sometimes even hours of footage have been taken, and only a snippet of what occurred in the courtroom actually appeared in the media. I am not confident that there is a problem here for a rule to address, but I can assure you that the Minnesota District Judges Association would be happy to address a well-defined issue. There's not one before this committee at this time. We would be also happy to react to a potential rule. But right now we have no actual rule language to respond to, nor a problem that has been clearly defined. For all of those reasons, I hope that this committee will not embark upon a rule change of Rule 4.02, that this committee will not limit judges' discretion. Judges are here to administer justice. We are public servants. We have sworn to uphold the law, and our commitment is to the people of the state of Minnesota. I'll pause here and I welcome any questions you may have.
Thank you, Judge Conroy. Appreciate those comments. Members, anyone have a question for Judge Conroy? So what happens when we're near the fourth? We lose some of our steam.
Judge Kyle,
Justice Deason.
Yeah, I just want to thank Judge Conroy for coming and taking time to speak with us today. This is a really important perspective for us to have, and also a willingness to kind of engage further down the road as we have more concrete things in front of us as well, which I think is important.
A pleasure to be here. I apologize to you all that I need to depart. I have litigants on my calendar this afternoon, but I am happy to respond in writing at any time should you have questions following today's committee hearing. Thank you again for all of your service.
Thank you, Judge Conroy. Thank you for being here. Okay, our fifth speaker is Walker. Go ahead.
Thank you, Judge Kyle. Thank you to the committee, and good afternoon. I did not submit comments in advance of this hearing. I'm happy to do so afterwards if that would be helpful. But my name is Lita Walker, and I'm here today on behalf of Hubbard Broadcasting and the Minnesota Broadcasters Association. I have represented news organizations on a variety of issues for more than 15 years. But over the past several months, actually going back to the trial of Mohammed Noor, my work on behalf of these clients has been heavily focused on ensuring press and public access to high-profile criminal trials. Specifically, I was heavily involved in the court's decision to live stream the trial of Derek Chauvin and also the decision to live stream the trial of Kimberly Potter. And I've been involved in ensuring a third trial will also be live streamed, that of Mr. Chauvin's co-defendants, which is scheduled for this summer. I've worked very closely with Chief Judge Barnett and members of the media on the coordination that went into live streaming the Chauvin and Potter trials. And I was in the courtroom myself for at least one day of Mr. Chauvin's trial. And I really want to speak to those experiences and answer any questions you have and provide a bit of an insider's viewpoint on those trials if I can. I've confronted over the past couple of years a lot of the standard and perennial concerns about cameras in the courtrooms, and I want to address them here. But I think I want to start with Mr. Mooring's question, which is a good one. There is no doubt that the Chauvin and Potter trials are shining examples of successfully televised trials, but I will be the first to admit that they are examples with limitations because they were so high profile. Mr. Chauvin's in particular. The court system, the media, the attorneys involved, everyone devoted untold amounts of resources to making sure they did their jobs right in that trial, to ensure that justice was served, that the trial was fair, that the media coverage was both comprehensive and accurate, that the public stayed safe, and so on. And not every trial, I'll be the first to admit, is going to get that level of attention or resources. In fact, not even Ms. Potter's trial got the same treatment by the media as Derek Chauvin's did. But both of them did get gavel-to-gavel coverage, and I'm not going to pretend that that's going to happen in every garden variety criminal trial that is the focus of some media coverage. The resources just aren't there. Viewers and readers, frankly, just don't always care about what the fourth fact witness to a car accident, right, might have to say. But the fact that journalists dip in and out of trials and they're present for the big days of testimony and closing and the verdict, but maybe not for some of the nitty-gritty in the middle, that happens whether cameras are present or not. And we don't condition the media's access. We couldn't condition the media's access on their willingness to be there every day. And they're not there every day because they have limited resources. And yet we still value access, we still value the media's presence, and we still value the coverage they provide, however sporadic, in the trials they do cover. And I have never heard, and I would love to hear your questions and concerns on this, but I've never heard anyone articulate why the lack of gavel-to-gavel coverage becomes so much worse if we add cameras. And so that, I think, is my answer to Mr. Mooring's question, and maybe he'll have follow-ups. So there's really four concerns that I hear day in and day out and that I grappled with in filing briefs in the Chauvin case, the case of his co-defendants, and Ms. Potter's case. And the first is that cameras create a circus atmosphere. But I just wish you could have been in the courtroom for the Chauvin and Potter trials, because these are not bulky cameras being wheeled around on giant tripods. We do not have cables and cords crisscrossing the courtroom and journalists buzzing around the perimeter, right? This is not O.J. Simpson. The cameras are small, remotely operated, and they're completely forgettable. The microphones are the size of the eraser on the end of this pencil. And if you talk to journalists who covered the pre-pandemic Mohammed Noor trial, at which cameras were not allowed, and the Derek Chauvin trial, at which cameras were allowed, They will tell you that only one of them felt like a circus, and it was not Mr. Chauvin's. I was also at both of those trials, and I can personally tell you that I've never been in a more solemn courtroom than the Chauvin courtroom. And I believe with all my heart that if you want to ensure solemnity and, frankly, efficiency of judicial proceedings, then the last thing you want to do is make people come to the courthouse, because they will show up early and they will wait in line and they will crowd into elevators and jockey for space in the courtroom. And in a high-profile trial, they will create a nightmare for courtroom security. But if you let them watch the trial from home, all those problems disappear. So the Chauvin trial taught me that cameras enhance decorum. They don't detract from it. The second concern is that trial participants, including the lawyers and maybe the judge, will alter their behavior or even grandstand. And I'm here to tell you, as a person who's in court with some frequency, I just don't buy it. I think most lawyers are focused on making their point, especially when they're trying a case to a jury, and are so preoccupied with winning that I think it's somewhat absurd to suggest they would mug for the camera. But it's also really backwards and absurd to think that cameras bring out the worst in people. If I know that my every action is going to be live streamed to the globe, you'd better believe I'm on my best behavior. And that's what we should encourage. I spoke to a criminal defense attorney after the Chauvin case ended, and he told me that he thought Judge Peter Cahill altered his demeanor a little bit because he knew he was on camera. And I said, oh, really? I don't know Judge Cahill that well. I hadn't appeared before him before the Chauvin case. And I said, how did you think he changed it? And the example this criminal defense attorney gave me was, he said, well, I think he was a little less gruff. I thought he was more patient than normal. In other words, he thought Judge Cahill's demeanor improved, which is exactly what you would expect when cameras are present and exactly what we should want. And third, I know that trial participants don't like the idea of being under a microscope. Certainly, you can find cases out there where the Rittenhouse case is one where judges said something maybe a little bit regrettable. And in this crazy social media world we live in, it gets more play than a lot of us think it really deserves. And maybe it detracts from what we all think the public should be focused on. But we shouldn't get to decide that. In the cases that are televised, in the cases that matter, a microscope is okay. And we should hold our judges, our public defenders, and our prosecutors to a high standard. And we should frankly expect them to withstand a little scrutiny and criticism, even if it's not deserved. The third thing people always worry about, and this goes to Ms. Townsend's question, is what about fair trial rights? What if witnesses, first of all, what if the jury sees this television coverage, which, you address that the same way you do any other kind of media coverage. But what about if witnesses know it's going to be televised and as a result, they're reluctant to come? And I'm going to put here in the chat a link to Judge Cahill's order in the Lane, King, and Total cases that dealt exactly with this, where he distilled and dismissed this argument. The defendants in that case argued toward the end of last year that the publicity surrounding Mr. Chauvin's trial had so intimidated witnesses that his co-defendants could only get a fair trial this coming summer if the cameras were excluded. In other words, a certain expert might not come back, right? But Judge Cahill quickly saw through the fallacy of this argument, noting that Mr. Chauvin's trial and the coming trial of his co-defendants is going to be the subject of intense public scrutiny with or without cameras. And we just saw that in the federal trial over in St. Paul. There weren't cameras at that trial, but there was still plenty of media coverage. There was plenty of community passion. There were plenty of news stories that could have made someone mad at a witness who testified on behalf of someone they disagreed with. All that the restriction on cameras meant over in the federal court in St. Paul was that the public had to trust journalists to interpret the trial for them. Journalists had to be the gatekeeper. Publicity may make ensuring a fair trial more difficult. You might need a bigger jury pool or more searching voir dire or more explicit jury instructions. But the presence of cameras have nothing to do with it. And there's a quote in the order I posted in the chat. Judge Cahill said, the notoriety of these cases is neither enhanced nor diminished by live streaming. So the last argument I often hear about cameras goes to witness, victim, and juror privacy. And of all the arguments I've grappled with, I will admit that this is the one that resonates the most with me. Attorneys and judges are in court voluntarily. They are paid often handsomely, and sometimes have even campaigned for the privilege of being in the spotlight. That's not true for witnesses, victims, and jurors, though I would note that sometimes witnesses, victims, and even jurors are very willing to be in the spotlight, and we saw this in the Chauvin case and in the Potter case and in many of the other high-profile cases we've seen. So I don't think it's correct to automatically deprive them of their agency with a blanket rule that says they cannot be on camera if they choose to testify. But they are involuntary in many cases. And I will acknowledge that sometimes these involuntary participants do need extra protection. But again, that was handled in the Chauvin case. Judge Cahill kept minor witnesses off camera, but still allowed their audio to be live streamed. The same went for members of George Floyd's family who testified. And jurors were not allowed on camera at all, and that's true in many states. Judge Cahill addressed this again in connection with the coming trial of King, Lane, and Tao, and it's all addressed in the order in the link. He said to them, look, if you have witnesses who won't come, and you can give me specific and compelling reasons, those were his words, about their reticence, we'll take it on a case-by-case basis. But a particular witness's reluctance to come to court is not a reason to ban cameras for all purposes. So Hubbard and the Minnesota Broadcasters Association encouraged this committee to recommend a rule change that would create a presumption of camera access at the guilt-innocent phase of trial, similar to the presumption that exists for sentencing. This does not rob judges of all discretion, to address Judge Conroy's point, but it does require courts to be thoughtful and not just bar cameras because they're not used to them or they're a little worried about how it would go or no one is quite sure how it would work or it creates an administrative headache. It would require judges to find good cause and to articulate that good cause. It would require judges to do what Judge Cahill did. And that's hard work, but it's work that I think judges owe the public. In considering this request, I want to leave you with two thoughts. First, if the past couple years have shown us anything, it is that large segments of the public have lost faith in the criminal justice system, not just in our police, but in our courts. And that is a huge problem. If you want to fix it, the first step is making it easy for people to watch justice unfold. And let me be very clear, telling them to come on downtown, the doors are open, doesn't count. Because think about what that entails. The right clothes, maybe a car, at the very least, a willingness to navigate downtown, its skyways, its parking ramps, its mass transit system. It requires time off from work. It might require a babysitter. I can do that, and most of you can do that. But a lot of people who don't trust our justice system can't do that. But they will watch the trial if you live stream it to their homes. We know because 23 million people watched the verdict in Mr. Chauvin's case. And the last thing I would ask you to think about is what the Chauvin trial might have looked like if we hadn't been in a pandemic, and if Mr. Chauvin had decided he didn't want his trial televised. Mr. Chauvin is perhaps the most notorious defendant to ever be tried in Minnesota. A police officer convicted of murdering a man in broad daylight, the perpetrator of a crime that caused our city to burn. And yet, under the current rules, Mr. Chauvin could have unilaterally kept cameras out of his trial, not because he articulated a good reason, but merely because it was his preference. I remember in the briefing on whether cameras would be allowed at the trial of the co-defendants, Earl Gray, attorney for Thomas Lane, even said, gee, I thought all we had to do was object to cameras. I didn't know we had to give you a reason, Judge Cahill. And Earl Grey, outside of a pandemic, is exactly right about that. Under the current rules, defendants have carte blanche to cut off the public's right of access. And I don't think we want in Minnesota criminal defendants deciding what the public gets to see. I don't think we want prosecutors deciding that either. Prosecutors work for us, the tax-paying public, and for that matter, and with all due respect, judges do too. And we shouldn't allow people to bar cameras just because they're uncomfortable with them. Cameras should be the presumption, and they should be excluded only if there's good cause. Thank you.
Ms. Walker?
Yes.
Committee members, any questions for our last speaker? Yeah, Sherry Townsend.
Thank you, Ms. Walker, for your comments. I appreciate them. One of the comments you made me think a little bit and it prompt this question. You know, here many of us are practitioners in the courtroom and are very concerned, be it defense or prosecution or judge, about the integrity of the proceedings. And I was curious if your request contemplates that the cameras would be there throughout, or something that you said made me think that it could be that there might be particular witness testimony that you would be more interested in, and there would be cameras in that circumstance. And it made me want to ask that question because there could be a perception by the decision makers of more value to particular testimony if there are cameras present for one portion of the trial versus another portion. What are your comments or thoughts on that?
Oh, so you're asking, do you need to be concerned about how the jury might interpret cameras being there on a certain day?
Yes, in terms of whether it would somehow emphasize the importance or the value of particular testimony without there being anything else besides the presence of cameras.
Yeah. I think that's a fair question. I mean, first of all, I think you probably are overestimating how obvious the cameras are to the jurors. In the Chauvin case, they were, affixed to the wall. There was a controller in a separate room who could remotely control the cameras. So they weren't allowed to pan or zoom, but they had control remotely. So it's not even like the jurors were aware that a camera person was in the building. And I think that would be, I think in general, you're probably overestimating how much jurors would notice. But I think the same is true whether cameras are present or not. There are some days where, oh, geez, the courtroom's really full today. We must be hearing from an important witness. Look at all the media. And then there are some days in a more run-of-the-mill trial where maybe it's just the family that's there. So I don't think that the fact that cameras are added to the mix changes how jurors perceive what's happening on a particular day. And, always the judge can give a curative instruction that, don't put too much emphasis on who you see in the courtroom. Just listen to the testimony and make a decision on what you hear.
Any other questions for Ms. Walker from committee members? You can just jump in. I'm scanning here. I don't see any hands, but feel free. Ms. Walker, you mentioned that you think it should be a presumption of cameras absent good cause, which is kind of that's basically our standard right now for the sentencing phase with a few carve-outs. And in the rule at the sentencing phase, we define what good cause should be. Things like the dignity of the proceeding, the physical facilities, the fair administration of justice, privacy, safety, well-being of participants. Do you think that good cause definition would work for the trial portion as we've got it right now for sentencing, or do you think we might need to tweak that if we were to open it up during the trials? And do you have any suggestions on factors that the committee might consider?
No, I hate to draft rules on the fly. So I would echo Judge Conroy's comments that if the committee puts a draft together, I'd welcome the opportunity to come back and take a look and offer more commentary. But I do think the good cause standard, while something short of the constitutional standard that Jane Professor Critley noted has served us all well, is a good starting place. I think the factors you see there are the sort of factors that Judge Cahill considered. I do agree with Professor Critley that the blanket exemptions for certain types of individuals is not a good idea. I don't think it's a good idea at sentencing. I actually think it's a worse idea at trial, because if you start carving out certain kinds of witnesses from camera coverage, then you're almost guaranteeing a skewed sort of coverage. Because the public wouldn't be getting, even if the media wanted to give them gavel-to-gavel coverage, they wouldn't be able to. But as a starting point, the good cause standard and the factors you see there, I think is a good place to start.
How about carve-outs for certain types of cases? That's what we do right now at the sentencing phase. There's a presumption, absent good cause, but even then, there are certain cases such as, basically criminal sexual conduct, sex crime cases that are not allowed under the current rule. Those are, and then treatment courts we don't allow at the time of sentencing. Again, this is post guilt. The Blakely trial, if there was one, for sentencing, our committee's had a couple meetings where we've been debating that. There was an earlier committee, this was about 6 or 7 years ago, that recommended that the Supreme Court not having those kinds of restrictions, just have the presumption at the time of sentencing without those kinds of restrictions. Do you have any thoughts on the sentencing portion, whether we should revisit those carve-outs?
Yeah, I agree with Professor Critley that blanket carve-outs are not wise. I mean, I think we can all imagine a situation where there's a child victim of sexual assault who has to testify, and the media doesn't even really want to put that in the news, in all honesty. But then you can imagine a sexual assault trial where an adult with full agency accuses a public figure, an elected official, of sexual assault, and that goes to trial. That's very important, right, for the public to monitor and see. And so blanket exemptions like that, I think, are a bad idea. I think judges are very capable of taking the good cause standard or a compelling government interest standard under the Constitution and applying it on a case-by-case basis. And I don't think the public deserves any less. These are the public's courts, and forcing judges to pause a moment and think about it rather than just having some rote checklist that they can say, well, this falls in this bucket, so I don't have to give camera access here. I just think it's what our courts owe the public.
Thank you. Any committee members have any questions for Ms. Walker?
I've got a question for Ms. Walker or anyone else who wants to.
I knew you would. Go ahead, Andrew.
So I haven't heard this mentioned, and I'm interested, Ms. Walker or any of the other kind of pro-expansion folks, their take on it. One of the collections of information that has come out of the pandemic-induced phenomenon of Zoom hearings and increased access to Zoom hearings is data that shows that the presence of that increased access influences outcomes, and influences outcomes in ways that are adverse to criminal defendants. Bail is higher, sentences are longer, and so there's been some mention, I know, Judge Conroy, about concerns about defendants' rights, but in the balance of things, there's been a lot of talk about press freedom, there's been a talk about victim privacy, and those are appropriate things, talk about decorum, and talk about public access. But if, in fact, the increasing access that is being discussed here, specifically related to cameras and video access, influences outcomes in ways that are adverse to criminal defendants, is that not something that ought to give us pause, ought to give the court pause?
Well,
maybe even, is that not something that would be good cause?
Is this anecdotal, or there's data on this?
Actually, I think Professor Critley talked about Justice Brennan. The Brennan Institute has a study that documents this. Now, that's one that's, I think, the most widely cited one. But no, it's not just anecdotal. It's academic.
Well, I mean, we have the Potter case as a stark example to the contrary. in recent weeks, right, where fully televised and the sentence was quite less, I think, than what many people expected. If judges are imposing sentences because they think it's what the public wants to see, I think the public should see that, and then we should trumpet the data and hold judges to account if we think they're trying to be hard on crime. So I don't think that's an argument to take cameras away. I think the transparency surrounding that is even more important. But I'm sure Professor Critley has thoughts too, if she's the one who cited the study.
Well, I didn't cite that study, but I have a lot of respect for the research that comes out of the Center. They do a lot of good work. I guess I remain somewhat skeptical of, is it causation or correlation? There's no question, I think. I mean, we know this. We've had several people cite the Nielsen ratings on viewership, that when people can watch trials, they will. And there's a lot of variation, obviously, based on many, many factors that judges have to take into account when they're considering things like bail. I remember years ago somebody said to me that the U.S. Supreme Court is highly susceptible to persuasion, not from the lawyers and the people who file front of the court briefs, but by public reaction. And having lived and worked in Washington, D.C. for 18 years, for many years, I said, well, that's just not true. They really try to look at the legal issues that are before them and make their rulings appropriately. Now, we can disagree or agree about whether that's still true. But, the buck stops with the judiciary here. And part of being a judge, I think, is to be prepared to, if it's appropriate, be impervious to the voice of the mob, which can be difficult to do, especially if you're facing a lot of public scrutiny that some would consider to be inappropriate. But, I go back to what Joe Spear said. It's really hard to argue that more information is worse when we're talking about the overall notion of public perception of the interests of justice. And different cases are going to have different factors. They're going to be nuanced. As judges and lawyers, you all know that. The public doesn't really know that because they're generally subjected to fictionalized accounts of trials, or they're listening to what is being spouted on social media, and they tend to think that that is the norm. So for me, frankly, if judges are being influenced by that kind of public attention, I think that we in the public have a right to know that. And, maybe that's something for continuing educations of judges to talk about. How do you deal with the reaction of the public? Because ultimately, they're the ones who pay your salaries.
I don't know if the professor could answer this, or Andrew Morning, the data, was that on viewing Zoom hearings, or was that from trials?
Can I suggest something, Judge Kyle?
Yeah.
I've read the Brennan study, and I have to admit, Mr. Morning, I'm not sure that I read it the way that you did. And I took from the Brennan study, especially the bail study, that the concern with Zoom wasn't judges playing to a larger public audience, that judges were, it's the argument that, frankly, that part of it I really agree with, which is it's a lot easier to set high bail when you're not in the same room with the guy looking him in the eye. The in-person, the cold distance that a video camera creates causes judges to set bail higher rather than they know that there's some large audience watching them. That was my reaction to the study, at least.
Thank you.
I mean, the data show what the data show. There's certainly that was one of the interpretations of the data, but bail was set higher in circumstances.
Yeah, that's true.
And so,
can someone send it around so we can all look at it ourselves?
I'll try and add the site to the chat.
We may have shared that information earlier. I can't remember, but let's share it on the chat, and then everyone will have it for sure. Okay. Any other questions for Ms. Walker? Otherwise, I'm going to pivot and kind of open it up if anybody else wants to make any comments. And we're at 2:30 mark, or getting close to the 2:30 mark. Any other questions for Ms. Walker, our last speaker? Okay. Well, thank you. Thank you for coming and presenting. Appreciate it.
Judge Kyle, I did have one question. The 9 submissions, are they going to be made public?
Yes, we will make those public, and Kyle Christopherson, I know, is here from the court's communication and media staff, and we will make them available free of charge to anyone who wishes to for a copy.
Thank you. Thank you.
Okay, hearing no other questions. We're kind of at the end. We have our 5 presenters, but I'll give we've got a little bit more time if there are any additional questions and answers. If any of our speakers want to weigh in and respond, I'm not sure we call it rebuttal, but if you wanted to come in and say something, I'll give you the chance. If any of our committee members were thinking of a question before and wanted to ask Mr. Davis or the professor or any of our speakers, you can weigh in right now. So we got some time, and I see the Andrew has shared that study in the chat. Go ahead. Also Friday afternoon. So, Mr. Spear, go ahead.
Yes, Judge. I did speak with Mark Anfinson, who many of you probably know, before this meeting, and he is the judicial media coordinator for most of the rest of Minnesota. Him and I share the state, but I only take two jurisdictions. And he reiterated to me that he also found very few complaints from anyone, judges, victims, throughout the state. He noted, interestingly, that it seemed to be more difficult to get into courtrooms with cameras in northern Minnesota. I'm not sure of the reasons because of that. Maybe there's a group of judges who speak with each other about it and decide it's not a good thing for their districts. But I just wanted to add that additional comment in that on the question of whether outcomes for defendants are worse, I would agree with Lita and Jane on that. I think they made very good points. But again, I thank the committee for allowing discussion like this.
Yeah, well, again, thank you for being here and for contributing. Anyone else question for any of our remaining speakers? Or yes, Professor.
Thank you. I just wanted to make one quick comment. I think Lita Walker addressed this too, and I don't mean to be ambushing the judge who had to leave because she had judicial duties to fulfill. But I really do want to emphasize that the argument about snippets distorting the public perception of trials, I think that has been discounted by the experience in every state that has been allowing cameras in the courtroom for a very long time, as for example, Florida, but other states as well. I don't think any judge in this state or anywhere else would say that the print media may not cover a trial unless they're going to submit a written transcript of the entire proceeding as something that's going to be published in their newspaper. No one is, at least I've never heard anybody argue that. There might be judges who would think that's the appropriate thing to do, but that's not the rule. And so the reality is that we're always dealing with edited coverage, whether it's electronic media or print media. And I know there are those who would argue that the visual image has a greater impact and in some respects could be distorted more perhaps than the written word. And I don't dismiss that concern out of hand. I think it is a legitimate concern. But ultimately, with all due respect, as the U.S. Supreme Court said in the Miami Herald versus Tornillo case, judges are not editors. That's not their role. They might like to play that role, but the First Amendment precludes it. And so I think that extends just as much to the snippet argument as it would to any kind of attempt to control how the print media would cover a trial. And I guess my point is the print media have been covering trials even prior to the American Revolution in this country, and it has served the public well.
Thank you. Any other questions, either from the committee members or any of our speakers have anything else you want to tell us? We're here for you. I'll I'll also note Chief Judge Barnett was mentioned by I think one of our speakers, and I'll just note that he's here, and he was a former committee member, and so we always try to highlight our former committee members, and I think Jessica also is here from the State Public Defender's Office, and thank you for being present. They've both been on prior cameras in the courtroom debates, so it's kind of a consistent thing at our committee. Any other questions, comments? Okay. Well, it's Friday afternoon, everyone. Thank you much. Again, thank you for our 5 speakers, the 4 that are remaining. Appreciate your comments. The committee will certainly take them all under consideration, and your written comments will also are appreciated, and they, as I said earlier, will be available from Kyle Christopherson. We'll consider it. We're going to be continuing to meet probably monthly. We've got a deadline coming up this summer, which I'm planning to meet, and we will provide some recommendations to the Supreme Court. They ultimately have the final say, but we'll have some recommendations. And I expect that there will be a public period that the Supreme Court will designate to give people and organizations another opportunity to weigh in once there are actual proposed rules. But this gives us a lot to think about. And again, thank you to our 4 speakers. And unless someone has something they want to say, I will conclude this hearing and the public hearing. Thank you, everyone. Bye.
Thank you, Judge.